morning. You may be seated. Sorry. We are here today on our case number 1 CACV140688FC, in re the marriage of Binder, help me. Binder versus Binder. Would one of the clerks please close the door back there while we proceed? Counsel, as you know, we allot 20 minutes for each side in the argument. The appellant may reserve any amount of time you'd like to for rebuttal. If you do decide to reserve time, you're in charge of keeping track of your own time. The clock on the podium reflects the total amount that you have remaining. We record these proceedings, so please, when you approach the podium, and for the appellant both times, we'd be grateful if you would recite your name and the name of your client for us. We have closely reviewed the record. We have read the briefs and studied them. We've looked at the case law, and we've also discussed the case in our conference. So with that, you may proceed.
Good morning. I'm Lori Vopel, counsel for the husband in this case, Roger Binder. And the trial judge in this case got it half right. He understood that long-standing Arizona Supreme Court case law makes it crystal clear that any increases in retirement benefits that are due to the post-dissolution efforts of the employee spouse are sole and separate property. That is clear in the trilogy of cases that were all written by Justice Holohan many years ago. And if it wasn't clear before Kolsch, it was made very clear in Kolsch. Where the judge went wrong here was in finding that Mr. Binder somehow should have foreseen back in 1999 that the trial court, when he eventually retired, would apply this according to where he ended up.
But don't we contract around that sort of thing all the time?
Your Honor, there was no way for the entire purpose for the reserved jurisdiction method and for the judge here to expressly reserve jurisdiction to implement and modify, if necessary, the orders to make it comply with Arizona law and with the intent of the parties is because there is no way to value it. There is no way to know when it's this far from maturing. Here it was vested, but it was not mature for another 15 years. Mr. Binder didn't know if he would be retiring in 5 years. He certainly didn't foresee that there would be 2 wars that he would accept the calling on and go back into active duty enlistment, or that he would work so hard and do such a great job for our country that he would receive a 3-rank increase to a 2-star major general.
Did Mrs. Binder and did the appellee know that stuff?
No.
Or were they on an equal footing when they were drafting the terms of this settlement?
They were on equal footing, but it was clear if you look at various places throughout both the marital settlement agreement and the order that they were talking about dividing this military retirement as the marital portion of it under Arizona community property law, which Kolsch was the law back then. And again, there is just no way for him to foresee that. In all of these other cases, there were issues that it was very clear from the get-go. For example, in Van Loan, the issue was whether a non-vested, it wasn't even vested or matured, military retirement pay was divisible as community property at all. So, of course, when the judge awarded it, that was immediately apparent, and they went ahead and appealed. In Johnson, there was a situation where they were trying to figure out, and the judge had discounted this particular, it was a 401k plan, a defined contribution plan, but because it was done because there were sufficient resources in the marital community to do a present cash value, they could go ahead and pay it out. And so there were certain discounts the judge, and Johnson took that opportunity, and Justice Holhand took that opportunity to talk about when present cash value versus a reserved jurisdiction method could be used. Here it's clear that the reserved jurisdiction method was appropriate because it could not be valued 15 years in advance for this defined benefit plan, and the property didn't have sufficient resources. So it was appropriate to reserve jurisdiction.
Here's my problem that I have with this argument is, I think under Zale, we look at the order. We don't look at the settlement agreement. We don't look at the parole evidence, the letters to McCarthy or whatever. We look at the order. And the order defined military retirement pay as the eventual retirement pay. Eventual disposable military retirement pay. Yeah. Thanks. Which, to me, seems pretty clear. It's whatever Mr. Binder would get. That was defined. The parties knew, at this time it was 10 years past Colch. The parties knew he was only 5 years, or he was 15 years away from retirement. Parties knew his situation might change, knew under Colch, as you argue, I'm not saying how that would play out, but knew under Colch that that was an issue. Could have asked the judge to enter a different order, defined it differently. Retirement pay as figured out in the end, something like that. So I guess if this issue could have been litigated at the time.
Your Honor, I disagree with that. And the reason for that is eventual refers to years of service. It refers to, you cannot determine in a defined benefit plan what the eventual ultimate points will be until you know the years of service. That does not mean automatically that it's whatever rank or grade he ends up with. And in fact, Mr. Binder even wrote a letter and said, I assume this will be, I'm assuming that this is according to, that it's valued as of today's date. In other words, that it is the rank and the grade at the time. Zale is different, and every single one of those cases are different because none of them involved a situation where there was a reserved jurisdiction award given. None of them.
Well, do we know that for sure?
Yes, I do, Your Honor. That is absolutely.
Looked at all the orders?
Yes. Well, Zale had an indefinite award of spousal maintenance with a review for potential changed circumstances, but that's true with respect to all spousal maintenance awards. That's not reserving the jurisdiction to determine the amount. They had a definite amount in that case that was determined. Spousal maintenance is different than what we're talking about here, and the ability to reserve it. Here there is an express order. For what other purpose? Because as Mr. March argues, had he stayed at the reserve as a reservist, and had he stayed, as lieutenant colonel, there would be no need. There would be no need for court intervention, Your Honor, to modify or implement the decree. They wouldn't even have to go back to court because DFAS could simply just calculate, here's the total number of points. There's a scale that they look at. But here, there were too many unknowns. And Colch says that there is nothing inherent in the word eventual, and they were relying, again, on a man who supposedly, was an expert in this field to help them divide the marital portion of the military pay. And the other cases, for example, in Ray Gaddis is another case where we're talking about the parole evidence and that you can't modify it. Again, there was no later modifications contemplated. Jurisdiction was not reserved for that purpose, and that involved a situation where the husband simply accepted a civil service position later on, and by doing so, He cut his pay in half, his military pay, and so then he only gave his ex-wife half of that. And the court said, you can't do that. You can't divest her of that property. And same with DeGrice. There, he tried to reopen a final decree pursuant to Rule 60 based on the U.S. Supreme Court case that later said, no, this is military pay is all separate pay unless Congress says otherwise. And by that point, Congress had said otherwise. It's defined by state law. And because, again, it was just a situation where it was just the award itself. It was not a situation where the reserved jurisdiction method was used. And the same holds true for both, whether it's a defined contribution plan or it's a defined benefit plan. The contributions made by the employee, whenever you have reserved jurisdiction, must be subtracted out of the final award, of the final, this is the amount that's community, that has to be taken out. That is exactly the same in a defined benefit plan under Kolsch and these other cases, that you have to subtract out the increases in rank and salary that are due to the post-dissolution efforts of the spouse. And there was no way that he could foresee this. He thought he was going to be a reservist. He didn't foresee 2 wars, with all due respect, or that he would go in active duty again and work this hard. And there is nothing in Zale, there is nothing in any of these other cases that precludes the judge today, now that we know the final end numbers, the final end points, the years of service, and what increases were due to the post-dissolution efforts of Mr. Binder, as opposed to simply the inherent increases in value. There's nothing in those cases that precludes this, because none of those cases involved an express provision that permitted and, in fact, required the judge to go back once he retired and determine this award and modify it if necessary.
Let me ask you to be sure to leave time to talk about the SBP.
Yes, Your Honor. I'd like to go to that now.
Could we jump to that? We may come
Yes.
back to this.
Yeah,
Yes, Your Honor.
I think the first question we have, and if it takes more time, we'll give you more time to talk about it. As things have played out, does the survivor benefit plan supplant the RC SBP in this particular case?
In this particular case, with all due respect, the order doesn't say that. The order says that he is to establish the RSBCP. Given that, Mr. Binder interpreted that according to the intent of the parties.
And so he applied.
And so what happened is he talked to somebody at the time. He didn't realize, because he was required by statute, it's USC 10 USC 12731A4. He was required to retire active duty. He did not know at that time that by doing that, it would essentially cause the RSBCP to not automatically convert to the SBP.
Okay.
As soon as he found that out, and realized that that was the case, he consulted with an attorney and he consulted with the DFSA people and said, I'm not sure what I'm supposed to do here. And they said, well, does she want it? Is she going to pay for her portion of the payments? Because the costs for that are split. And he said, I don't know. I can't reach her. I haven't seen her for 15 years. I don't know where she is. I've tried to locate her. I have no idea. And he was told by DFAS to, first of all, have his current wife fill out the paperwork to show I'm not entitled to it. And basically, it's almost a waiver. I'm not entitled to the SBP because the former spouse is. And that left it open for her to do a deemed election, which, by the way, Mr. McCarthy wrote a letter and told her, directed her, you have to do a deemed election.
And she did. So.
But DFAS didn't know that because they lost the paperwork.
Where we stand right now.
Okay.
Has the SBP supplanted
Yes.
the RC? Okay.
Yes,
So
Your
what-
Honor.
So we
They
can-
found the paperwork, and
So
so
we can
then.
be talking about the SBP. We don't need to talk about the RC
Correct.
SBP.
Correct.
Okay. Now, you just said Mr. Binder's wife disclaimed entitlement.
Correct.
So what's the issue then? If she has disclaimed entitlement and the, as I understood the issue from the briefs, it's whether the appellee is entitled to it. What's the issue now?
The issue, Your Honor, is that it's supposed to mirror. It is supposed to mirror the SBP can't be based on his pay as Major General any more than his military retired pay can be based on that.
Does it matter to your client and his current wife?
First of all, because this is a community property state, and former spouses, with all due respect, are not entitled to receive more than their community property share. And secondly,
But I thought you said his current wife has disclaimed any entitlement to it.
what she did was she had to, it wasn't a disclaim. It basically says, I can't have that at this time. If Ms., with all due respect, first of all, the payments are higher, okay? The monthly payments, the premiums for that, because they still have to pay a premium. So it's higher. It costs them more from day to day to pay for SBP benefits at the Major General level than it does at the Lieutenant Colonel. So that's one issue. It affects their monthly income. Secondly, if Ms. Binder, the former Ms. Binder, were to pass, then of course she would be able to have that. But primarily it has to do with the amounts that, are taken out and the premiums essentially that are paid for this. Secondly,
has she waived her right to take it now, but reserved her right to receive it in the future?
it's my understanding, yes, she could receive it in the future once the former spouse, yes, that you could elect that.
If she were to pass within the lifetime.
That's
then-
correct,
okay.
Your Honor. That's correct.
So, okay, so the only interest that your client has now is the consequence is it's a higher monthly premium.
Yes, Your Honor, that's my understanding. And an interest, with all due respect, in, right now, Your Honor, under the current award, and if you leave it and you don't make those consistent, then he will be even worth more dead than alive. With all due respect, that's
With all due respect.
somewhat disturbing. And it's inconsistent, both with the military retirement program and with Arizona community property law. And it should reflect it. And in fact, if you look at the Bonkowski case at page 454, it states that if wife were to receive a 50% survivor annuity, and this has to do even with the percentage too, that was our second argument that we're talking about, she would receive the entire survivor benefit, including portions that had accrued after dissolution and husband's remarriage, and which she would presumably have a community interest. Because that aspect has the effect of awarding wife more than her share of the community interest, we vacate the DRO in total. And I'm not exactly sure. I mean, if it were brought into alignment, with all due respect, and that's something I can look into and supplement if the court would like, to find out the effect, as I understand it, there can only be one survivor, one beneficiary listed. But I do believe that.
Well, if
Go ahead.
I'm confused. If she's entitled to it, if the first Mrs. Binder is entitled to it, and she's the one who's paying for the annuity, because she's, I mean,
The costs, there are costs, not the actual annuity. There are
But the
costs
cost to it,
associated.
okay.
That
Then if she's paying
the
for the
administrative costs.
what does your client care? I mean,
Because she's not paying the premium. She's paying half of the cost, the administrative costs associated with the annuity, not the premium amount. That's different.
Why does your client have to pay it if it's hers?
Because he's the one with the benefit, and because it's ordered under that she is to receive those benefits under the dissolution agreement. I only have a minute and a half if I could reserve that.
We'll give you more time.
Okay.
But, so your reading of the order is that it requires Mr. Binder to pay both provides that the first Mrs. Binder is the sole beneficiary of the survivor plan.
Correct.
And that Mr. Binder is responsible for the premiums of that plan.
That's the intent. It doesn't read exactly that way,
Okay.
but giving a fair reading,
Okay.
which he is trying to do.
And so I take it though that so the cost to your client right now, the reason that this is an issue for your client right now is that it costs more in premiums.
That's
monthly.
correct, Your Honor.
Although it seems to me, perhaps your client has considered the fact that in the event of the passing of the first Mrs. Binder, the second Mrs. Binder would be relegated to receiving less, probably, if you were to prevail here and the survivor benefit is reduced, but.
No, Your Honor, because that's pursuant to, that has to do with the former spouse. It would be a new election for current spouse. Exactly, Your Honor.
Okay.
Correct.
What other questions on retirement? Did you have more?
Right now.
Okay. Okay.
Complex.
Pardon?
Complex issues.
Yeah.
Let me ask one before we go on. I realize RCSBP isn't in play here, but when does the one transition to the other?
At retirement, when it's mature.
So even though that Mr. Binder went from reserve status to active duty status, he continued in a reserve component benefit plan until just before he became 60, at which time he would have to elect the SBP and the RCSBP would drop off.
Your Honor, if he would have stayed reserve status, it automatically would have converted without him having to do a new election.
Okay, so the same thing happens.
So
but he
long
actually
as-
has to make an election.
Yes, so long as there is also a deemed election paperwork. They need both, essentially. But yes, for him, he wouldn't have had to do anything had he stayed as reserve status.
All right, thank you.
Thank you.
Yeah, 3 minutes.
Okay. Thank you.
Thank you. Would you please add to the appellant's time 3 minutes?
We also add them to the first one.
And add it to the appellee's, I should have said both times.
Good morning, Your Honors.
Morning.
May it please the Court. My name is Robert March, and I am the counsel for the appellee, Shirley Binder. And even though this divorce was finalized 17 years ago, I may still refer to them as husband and wife, even though we have a new wife. So if there's any confusion, please let me know. We're here today to urge this Court to affirm the ruling of the lower court, confirming Ms. Binder's property interest as an application to husband's full retired pay.
Let's talk about full retired pay.
Okay.
And we jumped right into it with appellant's counsel. The McCarthy prepared order of 1999, about 4 lines into it, says that respondents' eventual disposable military retired pay be apportioned, and it goes on from there. Counsel says eventual applied to credits, but it didn't apply to things like increase in rank and things like that. Now, is there something we can look at, go back to, rely upon, where eventual is defined as anything other than just eventual? In other words, eventual is limited to.
Well, if we apply the plain meaning, and that's what I would urge this Court to do, the plain meaning of the words eventual, we look at, Webster defines that as the ultimate and the ending number. I, too, am confused with the terminology and the what I viewed as an attempt to create a vagueness for the term eventual. It's misplaced for them to argue that cost of living adjustments.
Eventual, or is that not eventual?
Well, they say cost of living adjustments require additional calculations resulting in an additional eventual number. But that's not the case, because this formula that was utilized by Mr. McCarthy in the clarifying order, or not a clarifying order, but a portioning order, would have resulted in a percentage. And that percentage would have been applied to military retired pay as a percentage, and had automatic cost of living adjustments applied to it. So there was no additional calculations necessary to come to the term eventual military retired pay.
Is there anything you know of in this record that might indicate that an eventuality of the appellant remaining in the military might be an increase in rank?
I think it would be expected. I think the whole.
And I don't know if it's expected or not, but there was certainly nothing that made that not a possibility.
Well, yes, and I too agree that the order apportioning the McCarthy order is the controlling order, and this is based upon and taken from language that was agreed to in the marital settlement agreement. But when we look to the order and the clear meaning of the order, we utilize it. And although it contains a lot of perhaps technical verbiage resulting from compliance with federal law and Defense Finance and Accounting Service, these parties did the correct thing, and that was at the time of the divorce 17 years ago, they retained an expert who knew these issues. And so when we look through, I think you can look through that order for some answers to your question. For instance, page 2, paragraph A on line 2, it says he's currently performing duty as a member of the United States Air Force Reserve. It was known, it was acknowledged by the parties that he was continuing to accrue service. There was no anticipation that he was going to continue not to continue to work. He did have his 20 years. That doesn't necessarily mean it was vested, however. It certainly wasn't matured, because as a reservist, he was not going to be entitled to receive retired pay until age 60. So while we specify here that he holds at that present time a rank or grade of 05, it's certainly clear that he had another 15 years till he reached age 60 that he could continue to accrue service. Now, that additional service was accounted for, and he was protected by our community property laws by use of the time formula, referred to as a Van Loan formula. And Van Loan, despite their criticism of the case, is the still approved case, or the case still approving the use of the time formula in a reserved jurisdiction method. And that bases a former spouse's interest in military retired pay or another pension as a formula, where the numerator is the number of months or points credited for service during marriage, and the number of is the numerator, and then the denominator is the number of total points of service or months required to reach retirement. And the formula set forth the number of points as of the date of marriage. We know as of set forth the points accrued during marriage. We know at the time of divorce what those points were. So the formula utilized that number. 4,849 points were credited for MRP as the numerator. And it's left open. And DFAS allows for this kind of order, called a formula order, when an employee spouse or the member spouse is continuing to accrue service. So that number continues to grow, the denominator, as he continues to accrue service and earn additional points. That decreases the marital share, increases his sole and separate property share, but we still apply it to the same ultimate eventual military retired pay. There was no defining language, no limiting language within this court order that says we're going to look to a date other than the date of retirement to value this pension. There's no hypothetical retirement date as of the date of divorce, as of the date of separation. It's just not there. And I would urge the court that Zale prevents or precludes the court from applying and imposing additional clarifying language when the terms are not vague and not ambiguous.
What of Ms. Vopel's argument that that Zales and some of the cases she cited are not reserved jurisdiction cases. What should we take of that?
Well, Kelsch itself is not a reserved jurisdiction case. In fact, Kelsch says we're not, because the benefit is immediately payable and the parties have an immediate right to receive those benefits, that we can't use a reserved jurisdiction case. And that's really what they're asking. They're asking for a kind of hybrid of a present value case formula, but defer wife's entitlement or her future right or interest in it to some point in the future. And that's not what Kelsch says, and their total reliance on Kelsch is misplaced in that regard.
But Kelsch is also talks about if you're entitled to receive it right now, at the first opportunity to retire, then that's when if you're not going to retire, then you need to pay your ex-spouse. You're supposed to start paying them their benefits,
Correct.
Even if it's out of your own pocket.
Correct.
But he was not entitled to retire at age 45. He could not retire. His first earliest retirement was at age 60. So really, Kelsch's, of course, Kelsch would not be a reserved jurisdiction case.
Right, and Kelsch doesn't apply because of that. Kelsch specifically limits its own holding or to applying to only matured pensions. And it specifically says when we have an unmatured pension like this one where the pension isn't going to mature for 15 years, that we follow the Johnson cases. Bunkowski later has affirmed that same thing. This court found and held that this very similar issue, that Bunkowski applies the Johnson reserve jurisdiction method. Now, what could have been done back 17 years ago, if the parties had wanted to look at it, was to determine what might have been wife's future interest in this, and bring it back to a present value, and perhaps do a lump sum payment. But there was no reasonable reason to do that. I mean, Mr. Binder himself didn't know that he would even make it 15 years to begin receiving retirement benefits. So he would have taken the risk then to say, okay, well, I'm going to pay my wife a lump sum payment so that my retired pay now becomes my own. But he may never reach the 15 years to receive that entitlement, that property interest. So there was reasons why the personal or the present value, lump sum buyout method was used. Clearly, the parties anticipated and clearly they intended to use the reserve jurisdiction method.
On the one hand, as you point out, if the parties had wanted a different arrangement, had wanted Mrs. Binder's share of the retirement to be calculated based on what he actually was taking, would be receiving at his future current rank, parties could have asked the court to enter the order, and the court would have entered that order. I get that.
Right.
But Ms. Volpel focuses on the last paragraph of the order. This court retains jurisdiction to modify this order and the decree in order to effect the provisions hereof. What do you think that, what did that contemplate? What kind of modification does that provision contemplate?
Well, I certainly don't think it contemplates rewriting the formula, rewriting the terms by which what the formula or percentage is applied to. It doesn't contemplate inserting the words that we're going to apply the percentage now agreed to be 25.8% to what husband's retire pay would have been back in 1999 as a lieutenant colonel. It doesn't contemplate doing that and rewriting the terms to that extent. In fact, it's limited to is that the court retains jurisdiction to modify the order to affect the provisions hereof, not to modify the provisions hereof, not to take steps to make sure that the intended property interest distribution as intended by parties and as agreed upon by the parties is affected. And really, that's the jurisdiction that this court did have. The jurisdiction had the ability to say, I'm presented with a case where Mr. Binder's retirement status has changed. It's changed from a reservist to an active duty member. So DFAS, and again, there's a lot of technicalities here, but DFAS will only acknowledge a court order, an apportioning order, for an active duty member that is based on the number of months. And unfortunately, this order was done with respect to a reservist position for the number of points for retirement. And, you know, we see some things now, and unfortunately, I now make my orders when I do these. I account for both now, because this is not the first time this has come up.
This actually raises a question we wonder about. From your perspective, does the order that Judge Herod issued, does that satisfy DFAS, or does it need further clarification?
No, it
from your
satisfies
perspective?
DFAS, because we were able to take that order from Judge Herod, and what DFAS needed was a percentage or an agreement by the parties as to what number of points were accumulated during total number of points for retirement. So we needed to give them a percentage.
Is it clear from, I mean, and just to make sure where we start here before we talk about vacating or amending or reversing the order, is it clear from your perspective that the support benefit plan amount is to be calculated on the Major General's pay?
The survivor benefit plan?
Yes. Sorry.
Yeah, I
think the Herod order says her portion of it. I mean,
right, and her portion, as defined by the court order, because again the apportioning order, the McCarthy order, we'll call it, addresses that as well. And in several places, it talks about how we elect survivor benefit plan, and so clearly it says using full retired pay as base amount. It was agreed upon.
You don't think there's any problem with DFAS as far as that's concerned, from your
Yeah,
perspective?
DFAS already has that in place, because I was able to help them locate in their archives Ms. Binder's deemed election that was sent back in 1999.
Is the whole issue about whether Mr. Binder elected or didn't or filed or not, isn't that all moot now?
It is. It is moot to the extent that I think there is an important point here too, and it's acknowledged by the parties and set forth in the McCarthy order, that at the time these parties divorced, prior to their divorce, during their marriage, when it became an option for the parties to elect reserve component SBP to take care of the portion between that time, that 20-year, and age 60, these parties elected to defer that option until age 60. So they did not elect, it took both of them at the time because they were still married, it took both of their agreement to not elect SBP coverage. So when husband in his reply brief says wife did not take risk here, wife took all of the risk here. And I want to point to the language that I'm referring to, and it's on page 3.
Of the order?
Of the order?
Of the order. Page 3 of the McCarthy order. And starting at line 3, the parties have agreed. Well, let's go to the first, because it says again, former spouse SBP be affected to petitioner's benefit with full retired pay designated as base amount, therefore. The parties have agreed, as provided in said marital settlement agreement, that RCSBP be affected using full retired pay as base amount to petitioner's benefit. Here's the important part. Both parties acknowledge, however, that these parties in 1995 or 1996, so this was 2 to 3 years, maybe even 4, before they started the proceeding, because 3 years, quote, elected to defer RCSBP election at that time, and that absent future modification of the law and regulation relating thereto, respondent is unable to make any further RCSBP election until or at his shortly before his age 60. So from the time of this decree until age 60, wife was not protected. If he had passed away before reaching age 60, her interest vanished. And at age 60, what would have been his age 60, it wouldn't have reinstated, it was gone forever. So wife took a big risk here And what I want to really expound upon, that these parties did do the correct thing. They retained the services of an expert to help them with the military retired pay issues. Mr. McCarthy knew Kelsch, he knew Van Loan, he knew all the cases that dealt with this. He knew that this was a case where husband continued to accrue service and that a Van Loan time formula reserved jurisdiction methodology was the appropriate order for this. He prepared it in accordance with DFAS rules and regulations. It was to be affected and would have been affected automatically but for the change from points to months. It had nothing to do with increases in rank or increases in pay. Again, the denominator would have continued to grow. It was taken into effect. This was not an interim order or an order served on DFAS, but saying, well, if circumstances change, we'll submit a new order, because that wasn't what was agreed upon by the parties. And Mr. Binder wants you to ignore or set aside 40 years of community property laws that relates to pensions. Van Loan's the applicable case here. There are tens of thousands of Van Loan formula quadros out there that base their distribution and the distribution of a pension based on the Van Loan formula, based on number of months of marriage during marriage of service over the total months of service. It's finality is required in this case, and while Mr. Binder probably didn't expect 2 to 3 wars, I guess we all didn't expect 2 to 3 wars, Mr. Binder's service to this country has to be commended. It should be commended. It's admirable. I thank him for his service. But, you know, his position coming back 17 years later and asking for this court to modify what wife bargained for and expected to receive 17 years ago and became a final order is unreasonable. I don't know if the court wants to address the issue brought up in the reply brief about whether or not the issue of Kelsch was is properly before this court. It wasn't brought up as a cross issue. I believe that the order or the opening brief said we have a situation here where this court order has to be interpreted in accordance with what we believe to be the community property law of the state, which we believe to be Kelsch. I think the issue's right before this court and can be addressed. And I think its inapplicability to this case is another basis or by which the court can affirm the ruling of the lower court. And in addressing one last thing about the Kelsch matter, Kelsch deals with and talks specifically about enhancements or increases to military retired pay or pensions that occurred post-normal retirement. And at page 182 in Kelsch, it states, quote, if the amount of the monthly benefit at retirement is greater than the monthly benefit would have been had the employee spouse retired at the normal retirement date, any increases will be due to the separate labors of an employee spouse. But again, that's talking about when we're able to define the actual pension benefit at the date of retirement. Until maturity and until the party is able and eligible for retired pay, we don't that pension or that benefit is not defined, and it continues to grow. And we can't look at that as in a vacuum. And all of our Arizona cases look at the years of service where it's a substantial factor, the years of service employed for a pension plan. We're not going to take 1 year and give it more credit than another year. We're going to give equal application to all of the years. And the Arizona courts have said that a non-employee spouse is entitled to receive their benefit based upon same. And so unless there's any other questions,
Thank you.
I think I'm done. Thank you.
Thank you, Mr. March.
We are not asking the court to rewrite any formula. Kelsch and this trilogy of cases dealt with two separate issues, and in Kelsch they were both present. Number one, whether to use the present cash value method or the reserve jurisdiction method, which is a separate problem and a separate issue from what you include in the calculation, regardless of which of those you use. Those are two different issues entirely. And nothing in Kelsch says that that's limited to matured plans. First of all, one of those plans was 6 months from retirement. And secondly, and more importantly, Justice Holohan specifically relied upon and incorporated his dissent from Van Loan, where he said, and that was military pay, you cannot award the portion of the increases that are due to the separate efforts of the employee spouse to the former spouse. And that was not only not vested, not matured, that was a non-vested plan. The judge said those are two separate issues, and they are being conflated here by the appellee.
But counsel, this refers to the eventual military retirement pay.
Nothing in the word eventual.
But combined with military retirement pay is my point. So there was something that was going to be an enhancer to that.
Yes, Your Honor.
Or possibly a reducer of that. I mean, I don't know.
Your Honor, in this reserve, because he was 15 years away, there is an enhancer. What the enhancer is the years of service. Okay. Your benefits go up the longer you serve, regardless of increases in rank. That's an inherent benefit to which she is entitled. And the COLA increases, according to Kelsch footnote 9, that is an inherent increase too. So she got the benefit already of him working and serving for 15 more years. What she doesn't get, and Kelsch could not be clearer on this when you read that in conjunction with the Van Loan dissent, does not get the contributions that are due to the spouse. The only difference in the Johnson case, for example, that dealt with the 401k. And so even though they did a present cash value, just like they ended up doing in Kelsch, because one was matured and the other one was 6 months from maturing, so that was a payment plan, was you can't do the employee's contributions. So regardless of whether you are calculating it according to the present cash value or a reserve jurisdiction method, you don't include the contributions of that employee any more than Justice Holohan said in Van Loan and incorporated into Kelsch. You include the increases due to retirement, increased promotions in salary, and rank. In fact, here's his exact words. And by the way, they didn't reach the formula in Van Loan. They couldn't reach the formula because it wasn't raised. And Justice Holohan said that's fundamental error because it is a fundamentally wrong formula that fixed the non-military spouse's share as a percentage of what he would later receive without accounting for factors such as promotions in rank, increases in pay for length of service, and other factors which are separate property. But
okay, you're out of time. So.
He does receive, they are separate. I just urge the court to not conflate those and understand those are two separate issues regardless of which formula you use.
Thank you.
Thank you.
Oh, thank you to both counsel for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. We stand adjourned now.